Okay, welcome. We're going to do 2014 July question 5. It mainly deals with trust, but there's a little bit of community property issue in it. The reason why we're mixing in community property with trust is very difficult to maintain on its own. Mostly the examiners do have it crossed over with wills, occasionally, apparently once with community property, even once with professional responsibility. So trust rarely stands on its own because one of the reasons is it's such a light subject. There's nothing in there. Okay. Before we, if you have not read this fact pattern, push pause, read the fact pattern at least 2 or 3 times so that you can understand this discussion. The discussion goes a lot better and you'll get much more out of it if you read the fact pattern 2 or 3 times. Okay, having said that, and hopefully you've done that, let's go to the cause of the question. Number 1, what is the likely result of Henry's suit against Sis? Okay, Henry versus Sis. Number 2, we always go to the call of the question first. That's something you should get in the habit of doing. If you're not doing it, you're minimizing your chances of passing. This goes for the essays, MBEs, and even on the performance test. You go to the task memo so you know what your assignment is, what you're called upon to do. Okay, number 2, what's the likely result of Henry suit versus Charity? Okay. Number 3, what rights does Henry have in the trust assets? H's rights in trust assets. Notice it says in number 3, answer according to California law. Well, if this one is answered according to California law, and the examiners go out of their way to say that for number 3, but not for numbers 1 and 2, what does that let you know? I'll tell you what it means. Number 3 is the community property. It can only be community property or wills. It can only be one of the two. So when it says answer according to California law, it'll only be wills or community property. Now don't give me this, oh, what about PR? PR will say answer according to California and ABA authorities. Evidence will say answer according to California evidence, or you'll even be in a California state court and the evidence rules will apply there. So they'll have you apply the California evidence rules. And federal civil procedure, they'll also determine that, but it will not say answer according to California law as specifically as it does here. So, community property, H's rights, and trust assets. These are the trust aspects of the essay. This is the community property aspect. The examiner separated for you. They try to make it easy for you, so make it easy on them and make it easy on yourself by not making this any more difficult than it needs to be. Okay, take it from the top. Henry and Wynne married in 2000. All right, so that's 14 years ago. Why are they telling me that? I'm not quite sure. During the first 10 years of their marriage, Henry and Wynne lived in a non-community property state. Well, if they're telling you they lived in a non-community property state, there's only one issue that the examiners are getting at, and it's quasi-community property. That means all property acquired in the non-community property state, if it would have been community property in California, becomes community property at death or divorce. Not when you move to California. It only becomes quasi-community property at death or divorce. Interesting thing about this essay, neither one of them dies and there is no divorce. Henry worked on writing a novel. Wynne worked as a history professor. So earnings, labor, equals community property. Of course, if it was California, it'd be community property. Because they're in a non-community property state, it's separate property. It only becomes quasi-community property at death or divorce. Wanda kept all her earnings in a separate account. So the fact that it's a separate account, what does that mean? Well, when you have an account in one person's name, check the source. Well, where did the money come from? It came from her labor. And what is that? That's community property. If you were in California, and that's when the quasi-community property kicks in. Okay, so that's what they're getting at here. We just broke it down sentence by sentence. That goes to call number 3. The first paragraph goes to call number 3. Everything else will go to 1 and 2. You're not going to know that until afterwards, but the fact is you're starting to figure that out based on what the community... You actually know that right now because you know this is the community property issue because this can't be wills or community property because they're not saying answer according to California law. Only call 3 is, so you know any wills issues or community property issues go here. So you already started to be able to organize this properly. All right. Eventually, Henry gave up on the novel, and he and Wynne moved to California. Like I said, just because they moved to California does not mean that it loses its separate property character. It only becomes quasi-community property at death or divorce. Okay. When then set up an irrevocable trust. So we don't know exactly where it's going to go, but we know we're going to have to talk about it eventually. So we have an irrevocable trust. Well, how do you create a trust? Let's talk about the creation of a trust. The examiners somehow want to see that, apparently almost every time. So we have the trust, purple birds. Trustee, purpose, beneficiary, intent, the res, which is the trust property, delivery, that means putting the money into the trust, and the settlor, the person who does it. The purpose can be for any noble purpose or any valid, legitimate purpose. Estate planning. The trustee, if there isn't a trustee named, the court will appoint one. The beneficiaries have to be identified. Unless it's a charitable trust, then it promotes society at large, and there's not ascertainable beneficiaries. So whether it's a private trust or a trust for the charity, depends on whether or not the beneficiaries need to be named. And the intent's always you can almost leave the intent element out. It's almost irrelevant. Okay. So, when then set up an irrevocable trust. An irrevocable means that Wynn's creditors cannot attach it because she no longer owns the property is owned by the trust. With the $100,000 she saved from her earnings during marriage. Now again, it should be quasi-community property because quasi-community property is property, it would be community property in California. Right now it's still separate property. So, ironically, when you find out what's the husband's rights in her separate property trust assets, none. Not until death or divorce. And because nobody dies, no one's getting divorced, apparently they're still happy, or at least they think they are, there's no quasi-community property just yet. Okay. Sis names Sis as trustee and Harry as co-trustees. So we have the trustees, Sis and Harry. And because they're both trustees, they both have duties. They owe fiduciary duties to the trust, and which we're going to get into. The duties of the trustee are actually going to be tested here. And they also have a duty to make sure each one of them acts reasonably. So there's duties of co-trustees. If Sis finds out Harry's doing something wrong, or Harry finds out Sis is doing something wrong, Harry must confront Sis about it and compel her to remedy the situation. And if not, probably petition the court to have her removed so he doesn't get in trouble because they have co-duties. Okay. So each trustee must exercise reasonable care to prevent the other from committing a serious breach of trust. All right. So Wynn directed that one half of the trust income was to be paid to her for life, and the other half was to be paid to charity. So it looks like the gift of charity is for a charitable purpose, to be spent only for disaster relief. Now these are the express terms of the trust. We know it's talking about charity here. So let's think about what the actual, it says here. Wynn set up a trust. She named Sis as trustee and Henry as co-trustee. Wynn then directed that one half of the income was to be paid to life. So half income to Wynn. Try to figure out what the terms are. I think it's paid her for life, and the other half is paid to charity. To be spent only for disaster relief. Only for disaster relief. So that's a charitable purpose. Give the money to the Red Cross so they can rip it off. And that at her death, all the remaining assets would go to charity. Okay. Charity is the remainderman. And here are the income beneficiaries, which is also charity. And so we have the income beneficiaries and the remainderman, which will bring up the issue of a trustee must act impartially when dealing with beneficiaries. So the trustee can't invest in a high income producing asset or investment and forget about the principal. So they must treat, that's the duty to act impartially towards each type of beneficiary, which we'll see it plays out in this essay. When invested all assets in W stock. Okay, well, Wynn invested all assets. And was Wynn a trustee? Wynn's not even a trustee. Why so Sis is a trustee and Henry's a custody. So how did Wynn invest all the assets of the stock? Which is interesting. I mean, okay, fine. I don't know why. For some reason, I remember when I originally read this, I thought that was a typo, but then I convinced myself that it wasn't. But I do find it weird that Wynn invested. Okay, so Wynn did it, and Wynn can do it. She set up the trust. I mean, it's her money. So, which paid substantial dividends. And stock dividends are, distributed as income, but decreased in value by 10%. So Wynn seems to have a preference for favoring the needs of the income beneficiaries over the preservation of capital. Obviously, because all the income is being paid to her. And you can't find Wynn in breach of trust because Wynn's not a trustee and it's her money, which is a little bit odd. Again, I still think it should say Sis. I guarantee it should have said Sis. Charity spent all the income it received from the trust for administrative expenses, not disaster relief. Because they violated and expressed, I swear, it's got to be Sis invested all the assets in stock. Because there's no way it should be Wynn. Because why is interesting. I wonder if the examiners ever would recognize that potential error. And of course, I could be off, but it doesn't make sense. But anyways, if that's the way Wynn invested it, fine. Maybe that's actually what they wanted to start off with, which is weird because they wouldn't bring up the issues. All right. So they didn't. The express term said you can only use it for disaster relief, not used for disaster relief. So the beneficiary or one of the trustees could actually, which is H, which is Henry, he can go back and have them disgorge the money, have the attorney general, whoever's got standing to enforce the terms of the trust, probably be a trustee or the attorney general if it's a charitable trust. Since they didn't use it for that, they would have to probably give the money back. Okay. Later, Sis sold all the stock which Wynn invested in and invested the proceeds in a new house. Well, she put all where she lived rent-free. Okay, so we have a couple of issues there. So we talk about the remedies. We talk about the duties of a trustee. And one of the duties are, we're going to put them right here. We don't have much room here. The duty of care, which is pretty much a fundamental duty. Prudent investing, which means you must invest prudently. Then there's the duty to act impartially towards all the beneficiaries. The duty to diversify, which clearly is not doing because she put it all in the house. And because she's living there, we have self-dealing, and that's the duty of loyalty. Self-dealing transaction. And then we're going to have to discuss the remedies for this. And the remedies are, well, you lived in the house, we'll get to that in a second. We lived in the house rent-free. Well, you have to pay the rent, so you're going to have to pay damages. You can have her removed as trustee for a serious breach of trust. They can affirm the transaction, but I don't see why they would. And the final thing is, well, they could actually have set aside the transaction, but at this point, we wouldn't need to set aside the transaction. So again, Sis sold all the XYZ stock and invested the proceeds in a new house in which she lived rent-free. The house increased in value by 20%. So by the house increasing in value, that clearly takes consideration of the remainderman's interest, but does nothing for the income beneficiaries. Because if you think about it, there's no income being paid to Wynn or to charity. And because they're the income beneficiaries, Sis is not acting impartially because she's favoring the remaindermen and not the income beneficiaries. She also, by investing in only the house, which real property generally is a sound investment, but putting all your eggs in one basket means you're not diversifying, which means you're not prudently investing, and it's a breach of the duty of care. Those all kind of dovetail. They're all almost one and the same in terms of duties. And because she's living there rent-free, self-dealing. So she's personally benefiting by her position in the trust. And if there's no self-dealing, then no further inquiry rule. She's going to have to disgorge, or she's going to have to pay the rent or the fair market value to the income beneficiaries, because if they rented the house out to a third party, it would produce income, and the income beneficiaries would get that money. So they're going to force sis to have to divulge or to pay damages for the income that should have been made while she was living there. So Henry has sued sis for breach of trust, and Henry is a co-trustee, and sis may be removed as trustee and required to reimburse the trust for the fair rental value for the time she lived in the house, as we discussed. And Henry has also sued charity for return of the income it spent on administrative costs, and it should be able to get the money back because, according to the express terms, it was only for disaster relief. So, what is the likely result of Henry's suit against sis? Well, we've created an irrevocable trust, and it was created properly. All the formation issues are there. And we have Henry versus sis is going to have to do with sis's breach of the trustee's duties. First of all, there's the duty of care, which is exercising the same degree of care, skill, and caution that you would with a reasonably prudent person would with their own money. And clearly that's not happening, so it's a breach of the duty of care. The prudent investor rules, taking consideration of the portfolio as a whole, the overall investment strategy. Taking all the money from one stock and putting it in one asset, that's not prudently investing. So put all the eggs in one basket is also similar to the duty to diversify. There's no diversification here. Diversification reduces risk. So she failed to diversify by investing all the proceeds of the stock and then sinking it into one property. I mean, what if we have a recession? What if the housing market crashes like it did in 1996 and in 2008? If that happens again, then it's not going to look like a wise investment, and she's not diversifying her assets to reduce that type of risk. So that's the duty to diversify. And of course, the self-dealing transaction by living there rent-free. She can't do that. And again, we talked about the duty to act impartially. Because the house rose in value, that helps the remainderment, but it's generating no income, so that actually hurts the income beneficiaries, and therefore she's not acting impartially. As we talked about, the remedies for breach of trust: compelled to pay damages, affirm to ratify the transaction, be removed as trustee, which is what's happening, disgorge any benefit wrongfully received, which is pretty much the same thing as paying damages, and also to have the transaction set aside, but there's no transaction to set aside under these facts. So that goes to call one. Call number two, we have a charitable trust, and we have express terms. Who can enforce the charitable trust? We're assuming H has standing. If not, for Henry, it would be the Attorney General would have standing to enforce the charitable trust. And the express terms, because there are express terms, as settlers said, this is the way it must go. The mandatory directions must be followed. And because the money was only for disaster relief, it was not used for disaster relief, it was used for administrative costs, Henry will be successful in getting them to disgorge the money or being able to reimburse them for the money that they squandered on the administrative costs, although 90% of all charities use money that comes in for administrative costs. Most people don't know that. Look it up, it's true. And finally, number three is the quasi-community property rights. So quasi-community property is property that would have been community property had the couple been domiciled in California. But during marriage, quasi-community property is treated like separate property for purposes of management and control. In other words, until death or divorce, quasi-community property is under the sole ownership, management, and control of the requiring spouse. Because this is Wynn's own property. It's her money. And they're not getting divorced. No one's died. It's her separate property, and he has no rights into the trust assets until death or divorce. However, if they were to get divorced or if they were to die, it would be community property because the earnings and labor are community property. And even though she placed it in a separate account, you trace it back, you look at the source. The source was the labor, which is community property. So until they get death or divorce, it's separate property. But once they do, when one of them dies, or there is, if Wynn was to die, or if they were to get divorced, then it would attach the quasi-community property label. And that is it. That's a wrap. That's an interesting essay for July 2014, question 5, trust and community property. Definitely a good mix. But the creation of a trust and the trustee's duties are extremely heavily tested issues in trust. Quasi-community property, fairly heavily tested in community property. And that's a wrap.